Take care, Mr. Parrish.
Mr. Patterson. Judge, this is James Patterson. He was out of custody, but his release was revoked based on a new misdemeanor. There's been an offer of supervision extended, but he would like for me to defend the felony case. So
Where do you want to go?
let's say the August 21st date. There may be a motion I file, and I'll get it on that week as well.
Sir, is your other case in Bay County, that misdemeanor?
Yes,
Is that still pending?
he's got a court date of August 14th on the misdemeanor.
Okay, so we're going to set you for 1 week after that for August 21st and let Mr. Meredith work on that and see if maybe everything can get resolved. I see there's something about the complaining witness being in jail somewhere else. All right.
Yes.
So it'll be August 21st. When you go to, your lawyer should know on August 14th that you've got this case pending, but make sure they know about it, all right? You don't need to do one thing until both of them are coordinated, probably. I would suggest you talk to Mr. Meredith before you do anything
Yeah,
on the
and
misdemeanor too.
he was on Friday, and I didn't get to the jail. And there's just about 2 or 3 more people I have to apologize to.
Okay. Take care, Mr. Patterson.
Timothy Bush.
Bush.
Your Honor, this is Timothy Bush. He's here before you in case 250495. And he is going to withdraw his previously entered plea of not guilty, enter a plea of no contest as charged to count 1, possession of methamphetamine, a 3rd-degree felony. Maximum penalty is 5 years in prison. Count 2, possession of paraphernalia, 1st-degree misdemeanor. Maximum penalty is 1 year in the county jail. He'll have time served on that misdemeanor. On the felony, he'll be, on both counts, he'll be adjudicated guilty. On the felony, he'll have 24 months or 2 years of felony probation. He'll have court costs and fines of $1,078, 100 hours of public service work at the rate of at least 8 hours each month, $20 a month for the cost of supervision, a drug and alcohol evaluation, any counseling is recommended, random UAs at his own expense. He'll have to enroll in that evaluation within 30 days of sentencing. Provided an example if one's required, forfeit any items that was seized. Defense is not aware of any exculpatory DNA and will stipulate to the facts for purposes of a plea.
Mr. Bush, did you understand the announcement of your attorney?
Willie Goldsmith.
Do you have any questions about anything?
No question.
Are you under the influence of any drugs, medications, or alcohol?
No, sir.
Are you being forced, threatened, or coerced to enter this plea?
I couldn't hear you. I'm
Are
sorry.
you being forced, threatened, or coerced to do this? Is somebody
No, sir.
making you do it against your will?
No, sir.
Is there anything about you today that would keep you from understanding what's going on?
No, sir.
This is really printed on here very lightly. And you agree that with your attorney,
I can have him sign my copy. It's a little easier to read.
well, let's let
Right here.
Debbie or Jill look and see if they,
So nobody's reading it off the mic.
well, I can read it. I just want to make sure for the clerk's purposes that you can read that. That'll be scan okay. Okay. Okay, good deal. So when your counsel says that she's agreed that the state could prove a prima facie case, do you understand what she's talking about there? Okay. Parties agree that the score sheet as submitted is correct?
Yes, Your Honor.
All right, I'm going to find that your plea is freely and voluntarily made with knowledge of the consequences. There's a factual basis based upon the agreed upon facts. You are adjudicated guilty. You are, is that right? Yes. You're sentenced to 24 months probation. I'm going to initial that so it doesn't look like somebody wrote it in afterwards. Sentence will be concurrent with both counts. The one count you can only get 1 year probation on. But do we say time served on the misdemeanor? So you've just got the one count. Your costs, fees, and fines total $1,078. You will, during your time of probation, do 100 hours of community service work at the direction of your probation officer with a minimum of 8 hours a month. Your cost of supervision is $20 a month. You'll submit to a drug and alcohol evaluation. Counseling as recommended. You have to do that within 30 days. There's zero tolerance for the use of any controlled substances, random urinalysis at your own expense. You'll submit a DNA sample. You'll forfeit any seized contraband items. And that is it. Did I leave out anything?
No, Your Honor.
Sir, do you have any questions?
No, you're fine.
All right, you
have
know
any
that
questions for the judge, though?
I have no questions. No questions.
you haven't been in here to see all the other people that are getting out. So it's going to take them a little while to process you out. It'll be sometime today. Go see the probation officer the first chance you have. Okay.
Goldsmith, if you want to come on up. Yes, sir. Sorry, yes, sir.
What are you doing? Yes.
And before you is Willie Goldsmith. He's here on two case numbers, 24-12-16 and 24-12-12. This is actually Miss McCarthy's case, and I'm standing in for her today. She informed me that I believe it was yesterday, there was a motion that she had filed. The judge entered his finding, I think it was yesterday, and denied the motion. Based on that, she has instructed me to set this for a trial date, and I think, Mr. Sullivan, do you have a particular date you want to set this on?
Judge, we're currently scheduled for August 4th. However, my case agent is on vacation. It's the same one from one of the earlier today. So I'm asking for this to be set for September 2nd.
Sir, did you understand what all that's being said? So I don't know what your motion was that was denied, but you're set for September the 2nd. Let's put you on that trial date. We should be able to get it done then.
You're going to be a trial management or straight to trial date? Okay.
You're just.
Yeah, if you have something that needs to be done before that, you can always get back in before then, okay?
Right. I'll show you that motion, okay?
Judge, Mr. McLemore is here for pretrial on case 24-2305. There was an offer made, a global resolution for the case that is scheduled for arraignment on August 18th. However, we weren't able to confirm a residence for Mr. McLemore.
Was
That's
it
still
going to be community
available
control?
if he wants to take it to get out.
Is that what it was? Community?
I've already missed the
It was, yeah. If we could keep this on the 8/18 arraignment docket.
Okay, so but you've got more than one case. They're all going to be on 8/18
Yeah, we'll do a
Which is
pretrial
what?
on this one and the arraignment on the new case.
on 18. 8/18 or 9/18?
It's 8/18.
Okay. Mr. McLemore, I'm sorry, I don't know all these dates, but we're going to bring you back on August the 18th, okay?
And we, Mr. Spinks? You know, the best offer that I've gotten on Mr. Spinks' case is 42 months Department of Corrections. So we're on the trial docket for August 4th.
What was the offer? How many months?
42 months.
Okay.
It was reducing it from a dwelling to a structure.
Mr. Spinks, you're on the docket for a couple weeks from now. Okay?
Yes, sir.
Your lawyer's working on it for you. Take care.
You need copies of this?
No, but I'll be out to see you next week. Okay? Yeah, we're going to trial. All right? You don't have to. We'll talk. Yeah.
Thank you. Thank you, John.
You're
Mr.
welcome.
Hall?
All right, let's talk about that. This hearing brought a mix of case updates, some resolving quietly, others heading toward trial. But as always, the judge maintained a calm, respectful tone and kept the docket moving. First up, we had James Patterson, whose release was revoked due to a new misdemeanor. He's now back in custody while his lawyer coordinates both the felony and misdemeanor matters. With the misdemeanor set for August 14th, the judge wisely aligned the felony pretrial for August 21st to keep things on track. The main takeaway here: don't act on one case without knowing what's happening in the other. Sound advice, especially when a complaining witness might be sitting in jail elsewhere next. We saw Timothy Bush withdraw a not guilty plea and enter a no contest plea to possession of methamphetamine and paraphernalia. This one had a clear resolution: adjudicated guilty, time served on the misdemeanor, and 24 months felony probation, with all the usual terms: community service, supervision fees, a drug evaluation, and random UAs. Bush was polite, clear-headed, and said he wasn't under the influence, though he did seem a little thrown off when asked if he was being coerced. Still, no red flags here. The judge ran through the sentencing carefully, even initialing part of the document so it wouldn't look added in afterward. A small gesture that shows just how meticulous the bench is. Then came Willie Goldsmith. His motion was denied the day before, and his case is now headed for trial on September 2nd. The judge made it clear this was a trial management day, meaning it's going to move forward unless something changes. Goldsmith didn't have much to say, and frankly, not much was needed. The decision had been made, and the next step was clear. The next update came from Mr. McMahon's case. This one's a bit murky. A global resolution offer was mentioned, but they couldn't confirm a residence for community control. That's a key issue if someone's hoping to get out. So instead of pushing a plea, they left it on the arraignment docket for August 18th. It's a good reminder that logistics like where you'll live can determine whether a deal works or not. Finally, we had Mr. Spinks, who's on the trial docket for August 4th. The offer on the table: 42 months in dock with the charge reduced from dwelling to structure. That kind of reduction can make a big difference on the sentencing side. Spinks didn't say much. His attorney noted they'd visit next week, but the trial looks likely. The judge kept it brief. You're going to trial, all right? You don't have to. Delivered without judgment. Just clarity. Overall, this hearing was a mix of pretrial maneuvering, plea resolution, and trial preparation. It had moments of compassion, quiet tension, and even a little paperwork confusion, but the tone stayed professional throughout. If there's a theme here, it's that behind every legal step are layers of coordination, whether it's depositions, housing, or motions just denied. And through it all, the court keeps ticking forward. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.